to experience something we got in this world. To me, I go deserve something better. Even though she probably had a good life, but way good life to me, I had to do it, man. That's all I come down to is that. That's the only way I felt good. I felt like, now, that's what I can say, like, I'm not thinking, I'm not, there's nothing, like, I'm just kind of undefeated, like, I've always been defeated, but now I'm just kind of like, you know what, I finally got to show how I feel. Like, I finally got to show the pain that's been going on with me, and now some other people can feel it. Because I'll tell you right now, I mean, I wish that's what the only thing I regret is that I wish that I could have instantly probably, killed her instantly instead of having to shoot, like, listen to her make those sounds. But that's what I mess with, I'm sorry.
Right, no, you're okay.
But, man, that's what I mean. I mean, it's necessary in this situation, because even to this day, I'm sorry, today, while I was watching church and stuff, I was having horrible thoughts in my head, man. Like, no, I'm not saying like horrible thoughts of like, but it was remember stuff that I don't want to think about.
How can you get that out of your head?
I thought I could. I thought I could just do it and
just do it first. How can you get that out of your head?
Somebody even do that in the first place, but didn't think to do that and then just forget about it. No, that's far-fetched, isn't it? Like, it takes a heartless individual to do that in the beginning, but then to just try to carry on.
What's that thing about yourself? This is what something else.
I know.
What's your name? What does it say there?
Well, I don't know. I think Mr. Ordeal says I'm not a very good person. What it says, but I'm saying,
But if you actually felt bad,
yeah,
once she was told she was making
you're right.
Maybe you're like, maybe I'm not a piece of crap because a piece of crap would give it cause about her either.
You're right. I mean, it's just now. Sorry. That girl was very beautiful. She had no reason to die. That's what she didn't do nothing wrong to me, man. That's the fucked up thing that I keep thinking about. Is that I didn't even try. Like, I knew she was young. I didn't even try to be nice to her. Like I told him, I've done been nice to 20 girls in my more. Even when I pulled that gun out, like I told her, but I told him like she come out of joking, and she thought it was not real, or she thought it was not crap. I was just like, I just wanted to assert my manhood. You know what I mean? That's all it came down to, was just I wanted to assert my manhood.
Did it make you feel like managers?
No, it made me believe that opposite, to be honest with you, sir. I mean, I'll tell you that man, it didn't. I mean, it made me feel like an absolute. I thought about it a little bit, and I said, man, that was something else, you know? I mean, it would have been one thing to go get vengeance on a man or something, but I don't know what you know. I saw you, the most beautiful girl I've ever seen. I won't say that, that's all I feel is. That was I've never had the opportunity, like, I've never had the opportunity to even be in the presence of a girl that's that beautiful. Like, I've seen girls only like, I don't mean to cross this in no way that I ever have lustful thoughts about this girl. The only kind of girls I've ever seen that was that gorgeous were in porn videos. But it's like, this girl, I said, no, I don't want her to be subject to the lust of this world too, you know. That's all it comes down to really, is just the lust of this world and the spirit and heaven and hell. And I was like, man.
How about the other girl?
The other girl I saw difference because she stood right there beside her and didn't, like the third girl took off running right in an open fire, but that girl stood there and looked at me while I was shooting the light with warning. So I just put the gun on her and tried with guns, and that's when Lauren started making those noises, and I started shooting for her head. You know, I was like, this is not supposed to happen. Like when I was shooting another girl, when she started making those noises, my eye felt, oh my God, like stop it. You know what I mean? It was like, stop. It was that bad, man. Like, I really think about this. Think about hearing all those people running on the alley screaming, right? But her screaming was distinct. And I'll think about that till the day I die. Because I never thought that would happen. I thought that. But that's what I was angry. I was like, Jesus, show me you'll save somebody, an innocent person.
How many people have you seen get shot and killed on TV over the years? Because you already had it all right.
You're right.
But I was thinking of shot, but they're done.
They're done.
You're right.
You're right.
That was
reality. You're right. Yeah, look what you have. You're right. I've never seen anybody die in my life. You're right. I have sons, but I've never seen, that's what I may or may not have. There's that evil that you can be illusionist. I thought my mom was about to be killed one time and she wasn't. So it's just like I've had images in my head of people being killed. I thought that it's like, that didn't really happen. But this ordeal was different, and that's what I mean. Like with my own eyes, in my conscious body, conscious mind, like experiencing that, which is just the biggest bad thing. Some of the people who like stab people, and so those are really ruthless people. Are like, I don't know, because they say that nowadays it's an intimacy thing. I couldn't tell, because I was in my car, and I could feel for that girl, and that wasn't something I didn't necessarily want that. That's why I always trying to serve my manhood, trying to be as heartless as possible, trying to be the devil. You know what? I'm not the devil. I'm just Kody, man.
I guess you didn't succeed. Like you said, you just Kody.
I'm Kody with a heart. You know, I'm Kody with a heart. I'm not the devil with the hate. You know, I'm not the devil with the infinity. I'm just Kody with the heart, and that really does have a heart for people like that.
I wish you had found that out a different way.
Well, I found it out. It's just the the way the world works, man. Like, that kind of love is rejected in this society, in this world. Like, you try to show someone love, you're shot down. It's like they say, like, no good deed goes unpunished.
I don't know. I can't see it. I told you I'm not shopping, so if I see you start shopping for a car, if you want to just buy the first car you see, you're not going to shop for it. I need to buy the right one.
Oh, yeah, I'll tell you right now, my issue is patience, man. I do.
But yeah, you got to have patience.
I better get used to it, and
You got to have patience.
I think I kind of, well, now that's what I kind of lost sense of time after this happened. That's what it's like there for a while, man, I was in a real fiend, just frantic. I mean, I could go spend $30 or whatever on drugs, and an hour later, boy, I didn't even know 30 or 40, so. I'm just very relieved that my mom came out. And I know this is going to cause my mom and what I call them, but you know what? All it comes down to is money. So it's like, that's really, like one day maybe I can see my mom and then everybody, maybe I can see them in half life. But I just knew that the way this world works, man, that's what it was going to happen. Like, well, that's what you said. You're right. There could have been other ways I could have handled my issues. But that's what I thought about it. I was very upset with the emails. Very upset.
I guess that probably, I'm just guessing, but that thought you said just then probably having a lot more since this happened.
Okay.
And not before.
What do you think?
He said, I'll just make sure that I understood you.
Right.
I understood you. Just understood.
Oh, yeah, you're right.
Straighten out. I'm just saying that, you felt bad after this happened.
Yeah, you're right. That wasn't the feeling that I had
Before. Okay. But now you saw this happening, you know what it's going to do to your mom.
Well, yeah, like
Now you feel really bad.
that, and well, like I said, I'm relieved about being able to help her with money and things, right? I know in her mind, she thinks like me, she doesn't want to have to work, she doesn't want to have to, but I mean, like that was something that was really against, like that was something that was not going to conform to the ways of the society, and like, I understand who does, it's like they're big enough people to just bite their tongue and do it.
I've been coming to this building for 28 years.
But I thought I was every son. And like anybody else who talks to her, kind of just ignore her. I was the only person that she could talk to. Absolutely not listening.
You got any brothers or sisters? Or any sisters? Is it just you?
From my mom.
From your mom?
But I'm the only person that shows my mom that kind of respect. Like, when she talks, like my stepdad, she just like, he's so used to it that he just like, he doesn't listen to her when she talks. And that's not like, he's good with my mom. I'm saying that's something that my mom's like, I can tell that was the only reason why she kept feeding me that money is to have something like this. It's not her. But I understood her because I didn't understand what goes on. It's not a people man. And now that my mom said that didn't work out, who was my mom going to turn to? I was supposed to be a strong man that could live for her when she's dead. Who's going to take care of her when she gets older? Her and I said that a bump they can't take care of themselves. Because I said that they're going to take advantage of that. They don't love her. Even, it's like me, I love, like I step relative, but I love my mom.
Your mom always going to have that connection no matter where you're at.
The things are going to change. Like, she's going to get older, she's going to need me one day, and I'm not going to be able to do anything. She's not going to be able to see me. Like, that's the only time.
Well, I'm always going to have that connection because, like you said, she's your mom.
Yeah, you're right. I don't think she'll be able to meet me. I'll still be able to meet you. Yeah, I just wanted to be able to still talk to you because that's all I ever wanted is to talk to you. Now I can just talk to myself, but it's like all I ever wanted was someone that female outside of my mom. She's the only person that I knew that she was only showing me love because I'm hers. Like I wouldn't think anybody else that I'm worthless, man. It's just like I didn't ask that all day. I didn't ask what I could be. I don't think nothing's wrong with you, but apparently everyone else does. So I just really wish I would have just killed myself. But I thought I would, like I told him, I was stupid enough to think I was going to get away with this. I should have just went out in the field and shot myself in the head. Because,
Did you think about that before?
oh yeah. I mean, I couldn't, but like I told him, I was throwing out the gun and I went to go find the gun and I was just like, it seemed like it was working in my favor because I told him I was expecting to be instantly caught.
Well, sometimes it happens that way, sometimes it doesn't. Obviously, you can do it that's a Friday afternoon, and we all Sunday afternoon. 2 days later.
Yeah, not too far. I'm
just curious about how did you drive off or not?
I did. I was on your phone, but I had no money, man. I had no money, man. All I care about getting high. If I was like, if I don't have money to get high, I was going to be in prison. Because like, it's hell for me without drugs. So either way about it, if I have to go without drugs in the outside world, then what difference is it being in prison and having to go without drugs? There's not, because I'm still by myself. I'm still in 4 walls every day, all day, every day. Nothing's changing, so
That's what we said.
yeah, but it's different. Like, man, I understand. It's gonna suck, but I just mean, man, it really was sucking. It really got to a point where even being high, it wasn't helping.
You know you're about to do serious withdrawal.
I serious with opiates, and he's like, oh, no, they're not too serious.
When was it, if you don't mind, the last time you took it?
I guess it's probably, it was Saturday, or, no, wait, it was Sunday. You're right, it was Friday, that was the last day. I went right after that, I got 2 more 10s, and
This too?
well, after I'd taken 4,
Okay.
I'd taken 4 to shoot them.
Okay. And then 2 afterwards?
Yep. To try to just, that's what I mean, like, even after what I experienced shooting with girls, if there was no drugs, that's going to help me, man.
I think you're absolutely right. They wouldn't have really wanted to do it.
You're absolutely right. That's why I was too far gone, Too far. I mean, there's people who dabble and they get straightened out, but I was set in my ways.
So were you pretty quick with it?
Well, yeah, I mean,
Things that you did before.
yeah,
They run up to shoot 2 feet.
I was instantly like, fuck, I need something, but I would
Like,
like,
I'm so good. And then you go find something.
yeah.
I'm getting money now.
I had no money, so I just asked her to give me some. I said, man, I told her another story. I go, yeah, man, I do feel a little girls. Trust me, I feel like shit.
Yeah.
Horrible, man. Like right now, I just have nothing but cold sweats, and I feel really bad.
Does that usually happen whenever you go through it?
Absolutely. It's nothing but it's cold sweats, and that's it. That's all it is for me. It's cold sweats, and just
Getting those and any of that stuff?
yeah, well, that's it.
I don't know if you guys got it right.
That's probably yet to come. I mean, I don't know. Like today, I've been out of it today, man. I watched church.
You watch church?
Well, I do. Like I was stuck on the fence. I've been stuck on the fence for a long time now.
What graduate church we go?
It was the Baptist. It was the first Baptist. Yes, Ken Flow. And his sermon was on freedom. Was what he preached about this morning.
What do you want?
He said, God gives you, people think that freedom means being able to do what you want, but God gives you freedom is when he released the people from the Pharaoh of Moses. He gives people freedom to give up for the opportunity to worship him. It's not an opportunity for you, for your freedom. It's an opportunity to show your loyalty to God and to worship God and the righteous God, and not do things like I did, try to show loyalty to the devil, and that's not the way to go about life, but, I was just talking about, you talk about patience, man, that's one thing I ran out of is patience, man. But right now, man, I can't even explain to you, I'm going to the golf, I feel so happy, I'm so happy, as I can't explain why. I didn't feel happy until I got in here and confessed.
Sometimes that would be the weight off your shoulders. Yes.
Well, yeah, but I want people to know what happened. Well, again, I want to know what happened. I want the story to be told. That's why I wanted the story to be told, my story, because that's all I have. That's all I leave behind me. That's all I have is that story to show and throughout me. People, when I talk to myself, people, well, a single person talked about it or asked about it, and boy, I should have got the burst choking this time, People are outraged, I was like,
Think about it. This would be.
they have, if other people with kids, now they have to be careful, their kids are walking
Exactly. My kids walking home from school all the time. And what the hey, this is people with cell phones. It is all going to but I'm sorry, what's upsetting? What are people that side channel?
Oh, yeah, I mean, I factored in all this,
So you're right. I mean, I can see the social media, the church.
Oh, man, there was people thinking stuff like, this was in New York, saying, a girl, Texas girl, and her friend was shot by white supremacists because they were black and white were friends.
Yeah, that's one thing I saw this morning. I appreciate the media page and the TV station today.
Little did they know that I'm not really coaching black people, and they're like, the reason I have my mindset is from me and my black friend that was in the cribs. Me and him were like tight, man.
Right.
It's like, I don't have nothing against ethnicities of people or nothing like that. It was just she would love herself every day.
Right.
And that Friday that I was going to do it, I was ready to do it, she would have two kids, 2 friends with her. So I said, this will be a story. I knew in my head that there would be that race factor. Because it was the blacks. I always try to play the race card. And I knew
Well, that's what we're at right now. I mean, we're just, law enforcement speaking, I had it a couple of months ago, a month ago, and it's happening all over. I mean, both, officers getting shot, and, people getting shot also by officers. So,
yes, I've been listening to Charles Manson talking about the race war. Man,
That's a blast from the past.
you know what I mean? That's what I feel. Yeah, I think so. They were going to throw it, and they ended up trying to put it on the murder. But what I was telling them is that's what I was telling them is that when I first started out with the whole devil thing, I was listening to people like Charles Manson and statements like that. Then I went and experienced some of that stuff on my own in the woods. I fasted for damn near 10 days. I didn't eat or drink nothing. I should. I was seeing there. I mean, there was absolutely crazy hallucination.
I thought you could love everybody who died like that.
Well, that's the craziest thing I've ever done. I don't know. It wasn't fasting. I mean, it was fasting out of fear. Like, I didn't want to go out. I was running from the demons and the devil because, like, I pissed them off by exposing some of their stuff, and like they were after me, man, that they were the TV, the demon from the TV, the top was the person with their eyes. That's how you know when you're talking to a demon, into a person or from TV or whatever.
All right, that's it right there. When you're seeing all this stuff, are you stoned or you sober? How about yours?
It's not seeing it, it's knowing. Like there's stuff, there's stuff, there's stuff.
Are you sober?
I'm stoned because that's how I worship the devil.
Okay.
You know,
I know that.
like that's how I worship the devil is through drug use.
So you're blaming the worship of God?
You're right. Jesus is the person I am when I'm sober. He's the person I pray to. And I have no interest in the devil unless I'm on drugs.
So he's taking you down that path.
He has. And he stayed with me just like he did with Manson.
Well, you just said earlier also that, he's tricky with you.
Oh, yeah, like I told him, I look at the right stories. There's Ricky Castle and there's Richard Ramirez, which are called the Night Stalkers.
Exactly.
You know what, he killed 13 people, and that's a significant number in the occult, is 13.
Right.
That was significant, and how he solved that number 13. You know, but it was like, I researched all those people, so it was all influence and what happened.
And wow.
But I had people in front of me that would channel the demons to talk to me, to tell me what the actual hierarchy was. Because the Bible, when he fell from heaven, he took a third of the angels. Those are the actual demons or what. If an angel sins right now and falls from heaven, they're going to be captured and they're not going to have a good time.
No other choice, you know that?
Well, they're going to have a choice, but if they sin in heaven and fall now, they're going to go to hell and be victims to the original fallen angels and Satan. Because the original fallen angels and Satan is who runs the hierarchy of evil. And if you're dealing with a real cult, then you have to deal with, like, there's real intelligence. You know what I'm trying to say? Like there's a real entity that will have to come through a person and channel through them and tell you what needs to be told, because a person on their own understanding can't like, you know, what are they going to say? Hey, you stop talking about like what you're talking about. That's all they're going to be able to say. But for the demon to come and tell you stuff that you haven't told nobody, and to tell you, I know you, man, I know what you've been doing, stuff like that. You know, it's real, and that's just part of it, man. It's like, that's what I told them. Like, I'm not here to expose anything about it. I want to be honest with absolutely everything. So that's the truth. You know, just kind of the influence of what, if I had to build myself up to do something like this, you know.
I don't know if the other people want to talk to you, but as long as you're willing to talk. I mean, I was having this
I was just thinking about the medical forensic files. That's my favorite show. They show it. They have marathons, and I was like, sure.
Someone's worried about you. I mean, some doctors, some PhDs, and I hope it is to do, but I'm sure I want you to tell me.
Yeah, you're right.
But I watch the sexual also. I watch 48.
Yeah, that's what I told him. I said, 48 was
sometimes you watch this, I mean, a lot of SVU or...
no, there's some people just get on killing sprees. You have to wonder, man, if other people, if it's something that other people, that's what I kept saying to myself, I said, it ain't just me. You know what I mean? There's those other people who do the exact same type of shit, and, you know, worse, they really, you know, like...
I just want that, but also not talk to other people, to kill other people. Also, you know, sometimes it's self-defense. Sometimes it
And they still have to go to him for it, though, they don't know. So sometimes there are those people who have just defended themselves, and now they're in prison for murder.
Every situation is different.
You're right.
Every situation is different. You know, those folks have had, attorneys assigned, and they work ethic out, they work things out, the court system, but it's so important. You know, because everyone has a right to that.
Just even cops now are getting, they're defending themselves.
Every time an officer shoots somebody, they're always going before the grand jury.
Yeah.
So, I mean,
So they have to be careful. It's not like the cops just running around like
I
that.
think it's not the house of fear getting their story about what happened. In this room right here,
Just like me.
just I can't put this story out of it. I'm going to tell you what happened. All right, I did this, I made this stuff, and I did that, and he did this, and I did that. We put that thing together and go to the grand jury. The grand jury looks at the
Take aside.
Exactly. What? You're right. We need to go to court to be tried.
You're right. There's judgment, individual judgment. So that's the line though. I was angry with the police about it. They locked up all my homeboys that had for protection on indictments of meth in a conspiracy. And I thought that was a wrong. It's an addiction. He didn't even want to do it. And I was like, come on, bro, you're not strong-minded enough to kick a habit like this. And he to this day, but to that point of no return. So because he's in like the spirit realm. Like when he goes to sleep, he feels like he's getting choked and he's having trouble. Like he's too far gone. That's what I mean. Like he went to jail. He spent 30 days, got out and went about that too. And I was like, they're trying to give him a chance. But that's what I mean. Just kind of my input. So when they first found out that we had tried that, AJ Haney, he was like my brother, man. And they were pissed. He paid me for it. They took it from us. They said, if we ever catch you, and they were about to beat my ass. But I sure they would have been. I said, they saw loyalty in me, and they said, who'd you do this from? Because they knew who I liked from. And I sat there and told them.
They didn't have a choice. They tell you.
Well, they questioned me. I told them, I'm not telling you who I got it from. It was out of town, but it was nobody at this house. And they said,
I talked to a guy that's involved in the same thing as they are, and he said, that board right there will not fold on nobody else, you know, so he said, that board right there won't fold on, you know. But yeah,
He's gone, right?
Let's stop the statement there, 15-minute recess, ladies and gentlemen,
that's
jury
not angry
excused.
about that.
UT Southwestern School of Medicine in Dallas, and teach a class every other fall usually. And then I teach continuing education classes from time to time, including the classes that either psychologist or psychiatrist have to take to be court appointed to conduct both competency to stand trial evaluations and insanity evaluations.
So that course is mandatory.
If you want to be court appointed to do those things, yes.
And then have you testified at the request of the prosecution and the defense?
I have.
And pretty much what's the split there regarding prosecution versus defense?
Well, I've kept track of this since 1997, and since that time, I have testified at the request of the prosecution or the state approximately 60% of the time, and approximately 34% of the time at the request of the defense, and then the other 7% was at the request of the judge.
And what types of cases have you testified for in those situations? What type of offenses?
Well, all types. More that are serious, more that are crimes against person, and the most cases that I've testified in have been cases of murder or capital murder.
And have you testified in other states as an expert or in forensic psychology?
I have.
What other states?
Testified in New Mexico, Kansas, Colorado, Oklahoma, Arkansas, Louisiana, Florida.
And have you ever been retained by the defense and issued an opinion regarding not guilty by reason of insanity?
I have.
And on few or many occasions?
On few occasions.
And then have you been retained by the state and issued an opinion regarding not guilty by reason of insanity
I have.
on few or many occasions?
A few occasions where I was retained by the state and issued an opinion of not guilty by reason of insanity.
And how many times approximately have you testified regarding insanity?
About 25 times, that's an estimate, with the first time being in 1987.
And is not guilty by reason of insanity a common defense or is it rare?
It is not common, it is rare as a defense.
And then what is not guilty by reason of insanity? What does that mean?
Well, in Texas, each state can be a little different, but in Texas it means that it's an affirmative defense to prosecution that at the time of the conduct charged, the actor, as a result of a severe mental disease or defect, did not know his conduct was wrong.
And that's at the time of the offense, correct?
Correct.
And I would assume, doctor, that most of the time you aren't there at the time of the offense.
Most of the time I'm not there at the time of the offense, yes.
Okay, so what do you look for?
Well, there's always records, especially the more serious a case is, the more there is in terms of a police file. If there is a severe mental disease or defect, there's typically psychiatric treatment, either prior to the offense or afterwards, and of course they keep a lot of files on that. You can look to what the person says happened. You can compare that to the police report, the report of, if it's possible, of the victim or people that saw the offense, talked to the defendant around the time of the offense, and then you also talk to the defendant and ask them, even if it's 2 years afterwards or any other time, ask them what happened. What's their version of the offense?
And the person's presumed to be sane at the time in Texas, is that correct?
Correct.
And once the state proves the offense was committed, it's up to the defense to meet their burden of proof to rebut that and say that and prove that the defendant was insane at the time of the offense. Is that your understanding?
Yes.
Is voluntary intoxication a defense conduct in the state of Texas?
It is not.
And earlier when you read the definition of insanity, what does wrong mean?
Wrong in the state of Texas by case law means against the law, illegal.
And have you been retained by the state of Texas through me to give an opinion on Kody Lott and whether he was insane at the time of the offense
I have.
of murder and aggravated assault that occurred on September 2nd, 2016?
I have, yes.
And did I try to influence your professional opinion in any way?
No.
And do you have a professional opinion regarding the sanity of the defendant at the time of the offense committed by him on September 2nd of 2016 for the murder of Landavazo and the aggravated assault of Makayla Smith?
I do.
And what is that opinion?
My opinion is that at the time of the conduct charged on September 2nd, 2016, Kody Lott was likely suffering from a severe mental disease or defect, but it did not prevent him from knowing that his conduct was wrong.
And I've asked that the record reflect, did you author a report that gives the basis of your opinion?
I did.
And ask that the record reflect that the state has previously tendered a copy of Dr. Price's report prior to his testimony.
That's right, that's right. Record will so reflect.
And Dr. Price, can you identify the person that you conducted an insanity evaluation on? Is he the courtroom here today?
Yes, he is.
Can you identify him?
Yes, he has a blue shirt on sitting to the left of Mr. Rasmussen.
I'd ask that the record reflect that the defendant, that the witnesses identified the defendant.
The record will so reflect.
And before we get into your report, you're charging the state of Texas, are you not?
I am.
And what is your fee for your evaluation and your testimony?
The fee is $300 an hour.
And how many hours have you put into this case so far?
Approximately 25, 30 hours.
And that's a similar charge that you charge whether you're for the state or the defense or by the court, is that correct?
It's the same fee, yes.
And would you say that insanity is a pretty high burden for the defense?
Yes, it is, especially in Texas.
And yesterday, or the day before, I asked questions of the defense expert, and one of the examples was Jeffrey Dahmer.
Yes.
And he had killed and dismembered, I believe, 17 young males
Yes,
in Milwaukee,
correct.
and he was found to be sane at the time of the offense, is that correct?
Correct.
Despite the heinous nature of his conduct.
That's correct.
And then more recently, what comes to mind is the Christopher Kyle capital murder, and Mr. Littlefield, I believe, is the other victim, by an Eddie Ralph.
Yes,
Are you familiar with that case?
I am.
And he was found to be sane at the time of the offense by a Texas jury, is that correct?
Correct.
And how are you familiar with that case?
I was an expert in that case and testified at the request of the prosecution.
And what was your opinion in that case?
Well, it was similar to this one, that the defendant in that case, Eddie Ralph, was suffering, as they say, from a severe mental disease or defect, but in his case, it was substance-induced due to voluntary intoxication, and it did not, even though he was impaired by that at the time, it did not prevent him from knowing that his conduct was wrong.
And with regard to your report, Dr. Price, what are your evaluation procedures?
Well, always the place to start is a review of the records. In an insanity case, those are probably the most important things to look at. What other people saw, what the defendant said and did close to the offense. Like in this case, I mean, we're 2 years out from the offense. So anything around the time of the offense that I can review and analyze for his behavior, what he said at the time, is important. Again, if there are psychiatric treatment records, those are important to review, and excuse me, and I had those in this case. And if there's a statement given by the defendant at the time as to what he did, obviously that's important. And interviews of other people that may have seen or heard something, especially of the defendant at that time, are important, and I had some of those in this case. They did not reveal a lot in this case. Immediately following the incarceration of a defendant and until such time as it comes to trial, there's also frequently correspondence to people, and that in jail is monitored, and also calls that the defendant places are also taken, and those are made available to listen to, and those also can provide information, and those were present in this case. There are also 2 other psychological evaluations conducted of him concerning his competency to stand trial, and then, if possible, if allowed, I come to the court to listen to the other expert and to review anything that the other expert produces that outlines what his or her opinions are and what the basis of those is.
Okay, and so you were provided a copy of Dr. Falls' his notes, correct?
Yes.
And did I ask you to make this report that you made? Or is that something that you regularly do?
I don't remember if you asked or not. I regularly do write a report in every case.
And so you read all the police reports and their supplemental reports, which included interviews of various witnesses that were out there on scene at the time of the offense, correct?
Yes.
And you reviewed the summary of several jail telephone calls and listened to some also?
Yes.
On top of all the mental health records?
Yes.
And in addition to that, were you able to interview the defendant, Kody Lott, at the request of the court?
Yes.
And when did you interview Kody Lott?
August the 15th of 2018.
And where did you interview the defendant?
At the jail in Wichita Falls.
And one part of your examination or observation, you have a number of things that you look for, is that correct?
Yes.
Such as their general appearance and behavior?
Yes.
And how did you find the defendant?
At the time I saw him, his hair was at his shoulders. Overall, his hygiene and grooming were good. And of course, he was attired in jail coveralls.
And what was his mood and affect?
It was his affect, that's immediately the expression of emotions, was somewhat flat. In other words, wasn't showing a lot of emotion, but at times he did show emotion, smiled, laughed, and at the times he did that, it was rather inappropriate because it was when discussing the offense. Similar, maybe not quite as animated as you saw in the video yesterday when discussing the offense, being somewhat excited. He wasn't quite that animated when I saw him, but he did smile and laugh inappropriately at that time. He gave a history of some symptoms of depression since he was incarcerated, and some prior to that as well. He denied any previous experiences with being really active. We call it manic, except when he was high on drugs. He says that he would get that way with certain drugs. He did say that he had a long history of anxiety, of nervousness, especially as it related to being around other people. He was uncomfortable around others, and so that was part of the history that he gave to me. He did not show any signs of remorse about the offense. So that in general was his emotional status at the time I saw him in August.
And did Mr. Lott tell you that he enjoyed reading about the occult
He did?
and that he flipped through the Bible?
Yes.
And did he report to you any history of hearing voices?
He did report a history of hearing voices at times, yes.
Okay, and were those voices, were they inside of his head or outside of his head?
They were outside his head.
And does that have any significance to you?
Typically, when people are having a psychotic episode where they have what we call auditory hallucinations, those voices, whatever they hear, are inside their head. So that would be inconsistent with what we typically would see with auditory hallucinations.
Did he tell you if he recognized the voices?
He did. He said he did not recognize the voices.
And were those voices male or female?
He said they were both.
And on the day before the offense, did the voices tell him anything?
He told me that the voices on the day before the offense said, "Enjoy murder, and it will be worth it."
And did he tell you if there were any voices on the day of the offense, September 2nd of 2016?
He said he did not hear any voices on that day.
Did he express anything with regard to Satanists?
Yes.
And what did he relate to you regarding Satanists?
Well, he said that he was fascinated with the occult, with Satanism, with the supernatural, and one of the few times that he mentioned anything to me about Satanism around the time of the offense was that he thought he would get some kind of satanic award if he submitted himself to the devil. He further told me that he could relate to Satanists because they use drugs, and as he put it, they were kind of down and out on the outside of the mainstream of society, and he could relate to that.
And did he mention anything with regard to their use or acceptance of drug usage?
Yes, that he said that they that was another part of Satanism that he could relate to. He has, as we know, a pretty extensive history of drug abuse, and he remains interested in that.
And does he have a history of conforming to social norms with respect to lawful behavior, just generally without any specifics?
Generally, he does have somewhat of a history of conforming his behavior to the law, of a lack of conforming his behavior to the law.
And I'm going to jump to whether you performed any tests on the defendant.
Okay,
And ask you if you performed any tests,
I did.
and what types of tests.
Well, these are psychological tests. Technically, two of them, anyway, are what we would refer to as an inventory, where you present the person with a paper and pencil list of statements, and they say if it applies to them or not. They say if it's true for them or not. If it is extremely true, if it's somewhat true, false, or very false. So two of the tests that I gave were these personality and psychiatric symptoms as a way to gather this information from him and then compare it to large groups of people of his age and education to get to a quantified view of what he's saying he's like and what's wrong with him, etc. The other test I gave was one that I would read the questions with some follow-ups and to see how he answered those and then compare those answers to large groups of people.
And are these tools that forensic psychologists typically use?
Yes, we do. And in forensic evaluations especially, they're very helpful because they can give us information about the defendant's, what we would refer to as their response style. Are they trying to look much better than they are? Are they, in a sense, putting forth their best foot? Are they being accurate in their endorsement of these items? Or are they engaging in what we call false impression management, which means are they exaggerating problems? Are they endorsing problems that there's no other evidence for, to try to look bad, to try to look more ill than they are, to try to look more psychologically abnormal than larger groups of people who are known to be disordered don't endorse symptoms that much.
And so the first of those tests, I'm going to start with Personality Assessment Inventory, or the PAI.
Yes,
And did you perform that test on Mr. Lott?
I did.
And what were your findings?
Well, the most important finding on the personality assessment inventory is that it suggested that he tended to portray himself in an especially negative or pathological manner. In other words, he was exaggerating what he thought was the matter with him. And it actually makes the rest of the results very, you have to be very skeptical of those. So that was the major finding of the PAI.
And Doctor, based upon your experience and training, what does that indicate to you, if anything, given the charges and the plea?
That you have to be careful in relying too heavily on his self-report, on what he says.
And as a forensic psychologist, do you rely more heavily and find it more reliable a person's behavior or their self-reporting?
We always, in doing forensic evaluations, want to rely more on what people actually do, what other people have observed them doing, what there's a record of their behavior, rather than their self-report, especially by the time it comes closer to trial and they become perhaps aware of, at some point, a plea of not guilty by reason of insanity. So behavior is considered to be the kind of data that more weight is put on in a forensic evaluation than self-report.
And having said that, does the defendant's appearance today in court, as you've identified him, does he appear any differently than when you saw him at the Wichita County Jail when you interviewed him in office?
Well, his hair is longer, his beard is longer. He looks thinner than he was even, that was only, what, a month ago? Other than that, he looks very similar.
And then you also saw him when he gave a statement?
Yes.
Had shoulder-length hair and no facial hair or razor stubble maybe. Is there any significance to that?
Possibly. One of the things, and you heard this explained by Dr. Falls, that observance of appearance and hygiene can be important, that it can mean more mental disorder, but it also, a lot of times, is just related to being in jail. I mean, that's just, so it can be of significance, though.
And then, did you also perform the structured inventory for malingering symptoms, which is also referred to as SIMS test?
I did.
And what, if anything, was your opinion with regard to the results of that test?
When it came to symptoms of psychosis, neurological impairment, affective disorders such as depression, amnestic disorders, across the board, he grossly exaggerated his symptoms on this test, and that score was close to twice the cutoff that you would need to be suspicious of somebody faking bad, at least for sure, symptom exaggeration, negative impression management.
In fact, on every raw score, he was higher than the cutoff for the score for probable malingering.
That's true.
Okay, and what is malingering?
That's when a person either totally fakes or grossly exaggerates mental illness for some external incentive. It can be in a court of law. It can be to try to get less punishment. It can be in an insanity case. It can be in a competency case. In other areas, in a civil case where somebody's suing somebody else, the external incentive can be to get money. It can be people can exaggerate or fake a disorder for other people paying them attention. That's another external incentive.
And doctor, the cutoff for these specific categories such as neurological, the cutoff was 2. So anything greater than 2 indicates malingering, is that right?
Yes, that's correct.
And so his raw score was a 5.
Yes.
And then for affective disorder, the cutoff was 5 and his score was 7.
Yes.
And this is the interesting one for psychosis. And how do you define psychosis?
Well, again, as you heard a good description of it from Dr. Falls, that it's when somebody is not touched with reality, that they have thoughts that are not in touch with reality. They may hear things that aren't there, see things not there. Their speech, their behavior can be what we call disorganized. It doesn't make sense or it's hard to follow. So all those things constitute a psychotic disorder.
And so under that category psychosis, the cutoff for probable malingering is 1.
Correct.
And the defendant's was an 8.
Yes.
So 8 times what the cutoff value was.
Correct.
With regard to low intelligence, the probable cutoff for malingering is 2,
Yes.
and the defendant's score was 4.
Correct.
And with regard to the probable score of malingering, as far as amnesia is concerned, was 2, and his score was 2.
Correct.
And so the total, the cutoff score for probable malingering for the test is 14, and the defendant's raw score was 26.
Yes.
It's almost twice.
Correct.
And did you also perform a test on Kody Lott, the Miller Forensic Assessment of Symptoms,
I did.
also referred to as the MFAST?
Correct.
And what were the results of that test?
It's the one that I asked the questions out loud, and all the questions on that instrument pertain to either exaggerating the symptoms of psychosis or faking a psychosis. His score on that was a 6, which is right at the cutoff. The cutoff is at 6 is the cutoff, and that's what he scored.
And did the defendant give you, I'm going to go back to your page 8 of your report, regarding, did he give you a substance abuse history?
He did.
And what was that history?
Well, again, as you've heard, a pretty extensive history of substance abuse, with the exception of alcohol. He described it to me, he wasn't a big fan of alcohol. He does not have a family history that he knows of either drug or alcohol problems. But he has an extensive history since the age of 13.
And did he have any type of mental health history in his family?
He told me that his maternal grandfather was diagnosed with bipolar disorder.
And anything in his medical history that caused you concern or that of significance?
No, I did inquire. He told me that at 13, he had an accident on a bicycle where he hit his head. He was taken to the hospital, evaluated. They determined that he had a concussion, and he was released.
Did he give you any employment history?
He did.
And was he ever able to hold down a steady job?
It was very limited. 2 jobs, one at Sonic, where he told me that he worked for a year, and the other one was at Chipotle, where he worked for 2 months before he walked off the job one day.
Just walked off and never went back.
Right.
And then, as far as a diagnostic formulation, did you have one in this case?
Yes.
And what was your formulation for your conclusion?
Well, I will preface that with saying it was difficult. To arrive at specifically what is wrong with him is difficult, was difficult for me, for a lot of reasons. He does have a previous diagnosis of schizoaffective disorder, one of which was before this offense. It did follow an attempt to get him into drug treatment, where he did not stay at the drug treatment. He absconded from that very quickly, and then he was placed in the Harris County Psychiatric Center, where he stayed for approximately 60 days, and he was diagnosed with schizoaffective disorder. As I've said before, he has a history of drug and substance abuse that's almost always difficult to disentangle between a mental disorder that's not drug-related.
Doctor, on that, can you take drugs and then cause mental damage to yourself or a physical damage to your brain as a result of taking those drugs?
Sure.
And so in some instances, your drug usage, can it cause your mental illness or your physical difficulty in your thought process or your actions? Or?
Sure. If you take the right kind of drugs in large amounts for a long time period, it can cause you to have brain damage that can end up in changes in your behavior and the way you think, the way you can regulate your behavior, what the person is like. And that's, it also, of course, can change somebody's behavior, emotions, and thinking, even if it's not taken over a long time period, but if a lot is taken at one time for some time period following that, it can result in a disorder that if the person doing the diagnosing doesn't know that it's drug-related, it can be thought that it's not due to the drugs. I think the clearest cut example that I see frequently is some person high on methamphetamines where they get manicky, and they then are seen by some mental health professional, and they are said to be bipolar.
And what is manic?
Talk real fast, change topics, real tangential thinking. That talking real fast, we call it pressured speech. Being wired, being hyperactive, not needing much sleep, doing things that are exciting to them, not thinking about the consequences. So that's a manic episode.
And Doctor, in all the things that you've reviewed, the documents, the evidence, and talking to the defendant, do you have any indication that the illicit drug ingestion by this defendant over the years was anything but voluntary?
I do not have anything other than it was voluntary.
And if you have mental illness, can illicit drugs exacerbate your symptoms or your thinking or your actions?
Yes, that's one of the reasons that, like I said, it's difficult to disentangle what's caused by drugs and what's caused by something else.
And then back to your diagnostic formulation, I believe I cut you off.
Okay. Well, there's also his exaggeration of symptoms at this time is another complication. But I don't have a lot of disagreement with the diagnostic formulation presented to you yesterday by Dr. Falls. We know that there's a group of disorders that are the schizophrenic disorders that have these psychotic symptoms that we've been talking about. The defendant has been previously diagnosed with schizoaffective disorder, which is in that group, which means there's some psychotic symptoms and there's some affective or emotional ones, depression or a history of manic episodes. And I think that is a diagnosis here. It could possibly have been at play at the time of the offense. It appears to be at this time controlled by psychiatric medications. So that, I would agree with Dr. Falls. When you heard him talk about, this has been going on a long time with what he called prodromal syndrome, or prodromal symptoms, I'm sorry, that are looking back on it, when somebody has a schizophrenic break in their late teens, early 20s, family will sometimes say, well, you know, he always was a little odd. There was something off, or he was isolated, he didn't have friends. Hindsight, they can look back and see. And oftentimes those were what we call prodromal symptoms. Excuse me. There's another explanation for those, and I think it's at play here, and it's a personality disorder. We have two big categories of what's wrong with people in psychology and psychiatry. Mental disorders, most common is depression. They often say that's the common cold of psychiatry. Anxiety, but also these serious ones, these severe ones in the form of psychotic disorders. Those are mental disorders, mental illness, if you will. But people also can have a personality disorder. They're not sick, it's just the way they are. They usually have symptoms that we might all have sometimes, but with them it's more intense, and it interferes with their life. They may not be as distressed about their personality as other people are about their personality. So it causes other people problems as well. The easiest example I can give is we are all dependent at times on somebody for something. That is a common human trait. But there is a dependent personality disorder where they are so needy and so dependent on others they can't function in society well, and they're distressed by it. They can't make a decision at the grocery store about what kind of canned tomatoes to buy, and they have to call somebody. That's a dependent, so it's a common trait that's very severe in a person. There is a personality disorder called a schizotypal personality disorder. It's called that because it's, you know, in this family of schizophrenic disorders, but it's not that the person's going along fine in life and they get sick with schizophrenia, but it's just the way they are. A schizotypal personality disorder includes odd behaviors, fascination with the occult, with the supernatural, with magical thinking of some type, with being very uncomfortable around other people. And hence they're isolated, and they may talk about really strange sounding things with anybody at any time. So it looks a little like schizophrenia or a psychotic disorder, but it's just the way they are. What we know is somebody that has a schizotypal disorder is also vulnerable to developing a full-blown schizophrenic disorder, is also more vulnerable to the effects of drugs on their behavior, thinking, and emotions. And so my opinion is that that's one of the problems here in this case is that Mr. Lott has a schizotypal personality disorder. He also, of course, has the rather severe drug abuse, especially with cannabis and opioids, and that those two drugs, especially cannabis today, it's not the cannabis of the 1960s and 70s. It's much stronger, and including we have what we call a synthetic cannabis, or K2 is one of those, very strong. Those drugs can cause somebody to have a psychotic episode that mostly we think of that if they stop using, that should clear in 30 days. But there are cases where it doesn't. There are cases that it lasts for 60 days, a year, and for some, there's some symptoms, depending on how extensive their cannabis abuse has been over a long time period, some of those problems can be permanent. And in my opinion, I think with the cannabis and opioids that Mr. Lott had been taking and took on September the 2nd of 2016 played a role in this offense and caused him impairment in his thinking, his behavior, his emotions.
Do you believe, in your professional opinion, had he not been using marijuana or opioids, that he would have committed the offense?
I don't know.
And so you said that psychosis, which we talked about earlier, can be caused by the drug usage.
Yes, it can be.
So they can bring that on if you're vulnerable to psychosis.
Yes.
And then if you have that personality disorder and you surround yourself with individuals that enable you to, for example, a mother, and your mother enables that neediness and provides you with what you want, can it affect your personality disorder?
Yes, it can.
And based upon the information that you've obtained in this case, is it possible that Kody Lott's mother, Chrissy Rowland, was part of his vulnerability and fed his personality disorder?
Based on the information I have, I think that's is likely.
And in fact, did she know about his drug usage?
Yes.
And did she also provide him with money to buy his illicit drugs?
I don't think that she wanted him to use the money that she gave him for drugs. Instead, it was for his needs, other needs.
But she knew that he was a frequent user of illicit drugs,
Yes,
that he had a problem.
that's my understanding,
And
yes.
she even drove him to Senecor, which was the drug treatment facility that he left in the middle of the admissions process.
Yes,
And then she also provided him with money from time to time, even hid it around the house so as not to, or apartment, so as not to disclose the full amount, so he wouldn't chew it up with illicit drugs all in one day. Is that correct?
that's apparently the reason. I can't come up with any other reason for her to stash money that she was going to give to him in different places in the house so that he'd have to call her to get it.
And then she also knew that he didn't work or have any type of other source of income, correct?
That's correct.
And did you speak to her, did you have an opportunity to speak to her about her son, Kody Lott?
I did not.
And did you have an opportunity to speak to his father, biological father, David Lott, about his son, Kody Lott?
I did not.
And based upon the information you were provided, did they ever indicate in any statement or to police or otherwise that their son, Kody Lott, had been interested in the occult or Satan?
I don't recall any statements they made, but my understanding is they were aware of his fascination with that.
And this jury knows that the defendant, and saw the video of the initial stop of the defendant 2 days after the offense was committed. And they got to hear the video where the defendant is communicating with the officers, answering questions, and makes no reference to the devil or any type of delusion.
Correct.
And then the same thing with regard, they watched yesterday, the defendant's statement to detectives on that Sunday, September 4th of 2016.
Yes.
And for the first approximately, I want to say 45 minutes of that statement, there was no reference to Satan or the devil, or he didn't appear to be under any delusion.
I would agree with that.
And is that significant to you at all, that he can hold it together and not mention anything about the devil or delusions, and can lie quite easily to officers for about 45 minutes?
Is that of significance to me? Yes, it is.
And what is the significance?
Well, while people with a severe mental disease or disorder, their behavior can vary from day to day, just like anybody else's. It's typically not under their voluntary control, and they don't usually want to be that way. They can't voluntarily turn it on or off. With a person who's talking about delusions or false beliefs or odd things that we know that couldn't be true, they can keep from talking about it sometimes if they think for some reason they can. But it's difficult, and when they get an opportunity and a person is a sympathetic ear, then it's difficult to stop them. And you certainly can't talk them out of it usually. You can't say, now you know there's no such thing as that. There's no evidence of that. Well, then they usually turn that around and you're part of the delusion then, and or you don't understand.
And so, in those two instances, did you find the defendant, in your professional opinion, to be suffering from any sort of delusion during the traffic stop or the initial 45 minutes of the defendant's statement to detectives?
I did not see any behavior that was evidence of a delusion at those times.
And that's something that you want to look at because it's approximately 48 hours after the offense they committed of murder and aggravated assault.
It's more important than how that person is acting 2 years later.
Because you want to look at the time of the event or contemporaneous to the event. That's the most important time, is it not?
Correct. In an insanity evaluation, for sure.
And also, when the defendant is finally put into jail, he makes his first telephone call, which I believe you've listened to over the transcript of. He talks to his mother and his stepdad, and when they asked why he did it, which is the murder and aggravated assault of two 13-year-olds, he didn't say the devil made me do it, did he?
No.
Didn't say he was hearing voices that told him to kill, did he?
No.
And is it common for a adult child, when they're caught in by their parents of why did you do something, it's common for them to say, I don't know, isn't it?
That's my experience.
And then you had an occasion to speak to the defendant about his version of the crime, did you not?
Yes.
And what did he tell you?
Well, what I do usually is ask about what was going on in their life in the time period right before the offense, to see what their state of mind was then. And he described to me that his state of mind in that time period before the offense was a very stressful time in his life. He couldn't stop using drugs. He didn't want to go to psychiatric treatment or any kind of treatment. One of the reasons he gave is that he was afraid of blood draws, of them taking blood from him. And with regard to any drug treatment, he didn't want that because he did not want to stop using. He was on community supervision and having problems with that. He thought that he was not going to be successful at that because of drugs. And of course they do random urinalysis, and he just knew that he wasn't going to be able to stop. So he was under a lot of stress, and his supply of both cash and drugs was not as consistent as he would like.
Doctor, those are all his choices to make, are they not?
Yes. We think of our behavior when it comes to adherence to treatment and the commission of offenses being at least largely a decision on the part of the person. It can be an impulsive one, but it is voluntary.
And did he tell you about his obsession with Satan and Satanism?
He did. He told me that he spent a lot of time doing research on Satanism. He particularly cases involving a Satanist that committed an offense, especially that committed the offense of murder. And he did, though, tell me that he was only obsessed with Satanism when he was high on drugs. It was not some lifelong hobby or interest of his, but it was associated with drug abuse. And then I asked him to tell me what happened. He told me and gave me a coherent story, logical in that it went from point A to point B to the end, of what happened on that day.
And what did he tell you happened on that day?
Well, a lot of this is consistent with what you've heard, that he told me he did not know the victim. He didn't know her name. He thought she was at least 16. He was surprised when, after the offense, he found out that she was only 13.
I'm stop you there, Doctor. But in his statement, he admits that he knew they were walking home from middle school and that they were extremely young.
Yes.
I'm sorry.
He described her, and this is consistent with other statements he's given, as being very attractive, beautiful, he thought, and he would observe her on frequent occasions, right behind his mother's apartment, and he said that he saw her at least 5 to 10 times walking home from school. He told me this was planned, that it was not an impulsive offense, that he planned it and thought about it for at least 2 months. And again, he was really concerned about his legal status at the time and thought he was going to go to prison, and said that he thought if he's going to go to prison, he might as well go to prison for something that was worth it. And that was a part of the motivation for this offense. He thought the offense, what he was going to do, would somehow magically solve all of his problems. And while he didn't say this, a lot of his problems had to do with being independent, having money, not being able to stop using drugs, causing his family trouble with regard to those things. And the prison seemed like an alternative to that. So his parents were out of town on a vacation. He had a key to the house. He told me, this is all what he told me. He got the gun out of the safe. He got the gun in anticipation of something that was going to happen. He knew she had a boyfriend because he saw them together. He put the gun in a bag of some sort and put it in his Tahoe and took it to, as he said, unload on them. He had a choice of guns, as you've heard, either the .223 or the .22. He didn't take the .223 because he didn't want to cause any more physical damage than he had to, and he knew that his father really liked that .23 and he didn't want it to be taken from him, and that he took the gun and that planned this because, as he said, I didn't want a witness or anything. He left a note for his mother and stepfather. He did not want to get caught. Part of the plan was an escape route on a country road that was not traveled frequently. He was going to go afterwards, as a part of the plan, to this friend's house in Albany for more drugs. He had previously bought a police scanner app on his phone so that he could follow what the police activity was afterwards. He told me that he was intoxicated on drugs on the day of the offense. He told me something different than he told to Dr. Falls. He told me that he took approximately 8 to 12 hydrocodone on that day and smoked all of the marijuana he could that he thought could have been laced with something, either PCP or embalming fluid. And that's one thing that is sometimes done, that they would soak the cannabis in embalming fluid. So he told me that he was intoxicated. I did hear, and it made sense to me from Dr. Falls, that his tolerance for drugs was much higher than most people because he did so much drugs for so long. But based on what he told me, he was intoxicated on that day.
And so with somebody that has a high tolerance that takes that amount of hydrocodone, they can still function, can they not?
Yes. I don't know what the limit is. I mean, you could take, obviously, so much opioids that you could kill yourself. It happens,
Right.
as we know. But people with tolerance can take large amounts and still function.
And so he could still function to get the guns out of the gun safe with a key and a screwdriver, and then he can still function to know to rack the weapon and put it on safety. And then he can function so well that he waits and is patient for the victims to be walking by home from school at 3 o'clock or 3:15. And he can still function to operate a motor vehicle to get to the alley, which is approximately a block away and take a left turn. And then he has the ability to function enough to pull the trigger several times of that semi-automatic weapon and aim it at two 13-year-olds. And then he's certainly able to function enough to play it cool and get to the back roads and throw the weapon into a vacant field where there's high grass so as to be not found. And then he is tolerant enough of those drugs to make it to Albany, Texas, correct?
All that he told me that he could do, and he did. That's what he told me. He did say, though, that he was intoxicated, that he was feeling no pain and on top of the world, but he could act normal. That's what he told me. So he went on to describe the offense itself. The target, he said, was Lauren. You've heard this. The other girl, Makayla, was there, and as he told me, in the wrong place at the wrong time. And she started to run, is what he told me, so he shot her. But the Lauren was screaming, so he shot her from, as he said, from the lower part to the top part, meaning up the body. He told me that he didn't kill Makayla because he didn't have enough ammunition. He took the planned escape route.
And let me stop you there, Doctor. He told you that he didn't kill Makayla because he didn't have enough ammo?
Correct.
Did he tell you why he would have killed her?
He didn't want a witness.
And then did he also say that he didn't touch Lauren?
He did.
And did you ask him that question because one of the things you're looking for, I would assume, in a person that is claiming that the devil told them to do it or they're interested in satanical or theories or the occult is rituals?
Correct.
And what are some of the rituals a person that is truly interested in responding to delusions of such?
Well, they can be very strange and very bizarre, and it can involve taking a body part or I was on a case here in Fort Worth where the person drew with a razor blade a pentagram on the back of the person. Not drew, cut a pentagram with an X-Acto knife. So some bizarre part of all this that relates to the occult. And he didn't do that. He didn't also didn't leave any fingerprints or evidence at the scene that would tie him to that. He did, it was pointed out in testimony, he didn't clean the grass off of the rifle. He put it back in the safe with that on it. At the time I talked to him, I had not thought of that. So he took the planned escape route. He threw the gun out the window into the grass. He listened to the police scanner. He got more drugs. He got some Lortab and Xanax and took them and relaxed. Went back to the apartment, watched the news, looked at Facebook. His computer log evidence indicates that he was following the news on Facebook and other sites, as I recall from looking at that, quite frequently. He learned from that, as you've heard again, that they were looking for a black truck and they didn't have a description of the person. So he began to believe that he wasn't going to get caught. He went back twice to find the gun because he'd taken that from, that's what he told me, he'd taken that from his parents' safe. If it was gone, they would put two and two together that was likely involved in it, and that he also said that somebody might find it. And so it was thrown out of the car to conceal the evidence, and then it was retrieved and put back in the safe to conceal evidence. He destroyed the note that he left for his mother and stepfather, and then you know that he was later a lead. On the basis of the lead, he was interviewed by the police on September the 4th, and you saw that interview. In the beginning, he lied. He told me that he lied because he was trying to get away with the crime. But when they told him that they knew he was on the street that day he said, I knew they had me. And so that's when he said, it came clean. So that's the version that he gave me that is, I think, consistent with other evidence that we've seen.
And so he is telling you all of that 2 years later, and it's still consistent with what he said 2 years earlier to the detectives that day, is it not?
It is consistent both in content and also the way that he talks about it. Like I said, in the tape you saw, while he's talking about that, he's really kind of excited about it, smiling, laughing with at least during the time with Detective Casillas, and he does that with me when he's describing this without showing any significant remorse other than he would have liked to have not gotten caught. So he feels bad that he got caught.
Not that he did it.
Not that he did.
And finally, Doctor, what it all comes down to is, did the defendant appreciate the wrongfulness of his actions?
That's an important part of an insanity evaluation, and my opinion is, and as a lot of what you've seen already, that the behavioral evidence at the time of the offense, prior to it with the planning, the offense itself, and his behavior after the offense it is consistent with him knowing that his behavior was wrong, that it was against the law, that it was a crime, that it was illegal.
And even the defense expert agreed and had 46, I believe, items that listed that the defendant appreciated the wrongfulness of his actions.
Correct. I think I've done, I know that I've testified in about 25 or so insanity cases. The majority of those that I do don't go to court. I mean, if something else happens in the case. So it's probably close to 100 of these I've done. I can't recall an insanity case that I've been involved in that had as many signs that the defendant knew his conduct was wrong.
And are you aware of the defendant having a telephone call with his mother approximately 2 weeks after he'd been arrested, in which he and his mother discussed pleading not guilty by reason of insanity?
I am aware that it was about 14 days later, on the 16th of September, they had that discussion in which, on that telephone call, he told his mother that that was the plan, that he was going to plead not guilty by reason of insanity.
Pass a witness.
Mr. Rasmussen?
Doctor, let's start out, good to see you again this morning.
Good to see you too.
Let's start out first of all with, we've got a lot of agreement on things in this case also.
Yes.
Schizoaffective disorder is a major psychotic illness, correct?
Correct.
And it would qualify in an insanity evaluation as the severe mental disease and defect that would give rise to a finding of insanity.
I think in most cases it would, yes.
And your conclusions, you have a chance on page 15.
Okay. Okay.
Okay, and there's three major paragraphs there. The first paragraph, you provide an indication of that possibility, is that right?
That's correct. I think with his history of having been previously diagnosed as schizoaffective disorder, even though it was close to a time of heavy drug abuse, that was there after his arrest and incarceration. He definitely showed signs of a schizoaffective disorder, I believe a year after the offense, and he was treated for that. So I think that it was likely part of his mental state at the time of the offense.
And you're on the outpost.
Yes, sir.
Doctor, I'm going to show you what's been marked as Defendant's Exhibit 2 and represent to you, I believe these are records that you've reviewed, but I want you to go ahead and there's a lot of them. I'm not going to ask you to go through all of them, and I don't think the jury would want that, but just to make sure that these are records that you had access to.
Yes, these, I recognize the cover page These are the records from the UT Harris County Psychiatric Center. They don't, unfortunately, have these stamped for the number of pages here, and I didn't bother to count them. You can see they're extensive.
Right. And they have them down here some, but they've got additional pages.
There are, but there's at least 570 pages of text, and then there's test results. It looks like, gosh, well, here's another set of test results and all this that is probably another 100 pages or so.
And you can go ahead.
Okay.
What type of records are included in that stack? In other words, are those records that psychiatrists make notes and reports in there?
Yes, it's the treatment notes from the psychiatrist and psychologist there, from social workers, psychiatric nurses, mental health workers, or we used to refer to them as psychiatric aides. So all this are those people's observations and documentation of what they did to treat him for the problems he was having that they diagnosed as schizoaffective disorder.
And in that stack is also, that's a record of his behavior at the hospital, correct?
The observations of his behavior by all those professionals, yes.
And that happened at least a year before this shooting.
Approximately a year before the offense.
And in addition to, I'm going back to your conclusions and opinions, of course you mentioned the substance-induced psychosis, which is what your opinion is at this time, is that right?
Yes.
But you also indicate that ultimately multiple stressors led to his decompensation into a full-blown schizoaffective disorder. And then I believe you go to describe that, which is a combination of symptoms of schizophrenia and depression. And I won't go into the rest, but is that your finding?
Yes.
And so is he suffering now, separating a little bit from insanity, is he qualified for schizoaffective disorder at this time?
Well, the diagnosis at this time would be that, like many disorders and diseases, some of which are physical, that some of us have, we don't talk about cure too much. We talk about management of the symptoms. And at the time I saw him, and I assume now, with the psychiatric medications that he is receiving and the abstinence from drugs that is achieved through a controlled environment, he's managed, but we would still say that the disorder is there in remission secondary to psychiatric treatment and including, of course, the controlled environment.
So for treatment purposes, regardless of what determination the courts may make, he will need to be treated probably for schizoaffective disorder for the rest of his life.
That would be my opinion, yes.
When you say multiple stressors may led to decompensation, I think are you talking about stressors in life that would cause him to decompensate?
At that time, what I'm referring to is he was incarcerated by that time for approximately a year and in solitary confinement, as far as I know, for the entire time, with little to no contact with family or support from anybody. And that situation can be stressful, and it can trigger an episode of a psychotic disorder of some type.
And we don't know a lot about the long-term effects of somebody's incarceration. I know there's some studies done, but that's a little bit difficult to call in situations.
Well, yeah, there's a lot of studies, and that some show that it's so stressful for some people that it leads to episodes of psychosis. Some studies show that it's the best the person ever does in their life. We call it a highly structured environment where they don't have to make decisions about what they do every day. Those are made for them. And I mean, I've seen inmates that have graduated from college that, while incarcerated, that didn't have a high school diploma prior to that, but they are able to function in that highly
They don't have
controlled.
drugs, too.
And there's, I say that, and inmates have told me they can get anything they want. And I know from looking at files from prisons, there are some drugs available, but it is not like the free world. I always ask myself, so you're telling me if I gave you 20 minutes and some kind of currency substitute, you could bring back anything I wanted? And, you know, it's just...
But that's speculation.
It is, and I know it's possible, but it's unlikely. It's certainly not. The availability, accessibility of drugs is nothing like the free world.
Now, on your second paragraph there, this is where we discuss what you talked about, the evidence of knowledge problems. Is that correct?
Yes, that's correct. I'm sorry.
And you've indicated, I guess, rather six numbers or bullet points. One, efforts to avoid detection is an indication of wrongfulness.
Right. Yes.
So if there was a lack of effort to avoid detection, would that be a sign that there would not be wrongfulness possible?
Possibly. I have seen insanity cases where the defendant didn't leave the scene and eagerly awaits the arrival of the police to tell them what happened. And, you know, so...
That's where a person is insane.
yes, correct.
Okay.
Correct.
I guess what I'm asking is these, okay, you've got, let's go ahead and list them. Number one, making efforts to avoid detection, correct?
Yes,
Number two, maintaining secrecy about the offense, correct?
correct.
Number three, disposing and manipulating evidence, correct?
Yes,
Number four, avoiding apprehension.
yes,
Number five, attempting to avoid being arrested and charged with the offense by lying to the police.
yes,
And number six, leaving communication to parents before the offense in anticipation of being apprehended, but then later destroyed.
yes.
So my question is if there's evidence that contradicts these six things, that could be evidence that the person did not know what they were doing.
Yes, in almost every case, you can find some evidence for both, and that's where the weighing comes into play, yes.
And sometimes can the same fact be both?
I think it probably can be. I think it probably could be, yeah.
Did you observe any facts at all that indicated Mr. Lott did not know for wrongfulness of his conduct?
Well, there could be things that we don't know about. I can't think of a behavioral indicator that would suggest to me that he did not know it was wrong. Other than his self-report about this was in some way in league with the devil, and the self-report of those odd, distorted, unfounded beliefs that he had.
Do you see delusional indicators in the second half of the interview with the police?
Yes, I think in the second half of that interview that we saw yesterday, there were statements he made that had a delusional quality to them that were this, occult, odd, bizarre even beliefs intertwined with what, a distortion of his study of even Christianity and with philosophy. And so there were certainly some things that could be interpreted either way. He said, for instance, it was God that did this, and that one of the tenets of Christianity is thy will be done. And many people who are devout Christians would say that things happen, good things and bad things, because of God. So, but that was distorted in his interpretation of that.
And that's some indication of delusional thinking.
It at least has this bizarre, odd, distorted quality, yes.
One of the things that, of course, we saw the 3 hours of this interview and confession. When I was listening to you, questioning with Ms. Shelton, that was what he told you was that you indicated very consistent with what we saw. Is that right?
It was consistent in terms of the facts and what he did to attempt to not get caught, etc. When I interviewed him about a month ago, there was very little said about the devil and Satanism. He talked more about the motivation for this kind of stemming from the jealousy, which was odd anyway. I mean, wasn't rational for him to have these feelings of jealousy for a 13-year-old that he didn't even know. But he was angry about his past experiences with girls. And he talked more about that than he did, and as he did in the interview too, for the first half, than he did about the devil and satanic cults.
He was on medication at the time you talked to him, is that right?
Right, he was much more stable, right.
Back closer to the time, there was more discussion about the devil. Is that what you're saying? Back to the police interview.
Yes, in that it was like when he found a sympathetic ear and somebody that the officer even appeared to act like he was enjoying the conversation. I mean, so it was a good audience for him to talk about these ideas and beliefs that he had.
Opened him up and got the report that we heard discussed, is that right?
He kind of overdid it, but he did talk, to answer your question, he certainly did talk more about the devil and Satanism, etc., in the second half of that interview.
And to your knowledge, he wasn't on any medication at that point in time, is that right?
He was,
At the time.
at the time, yeah, he was not taking any psychiatric medication to control his symptoms. He was still under the influence of substance abuse, partly as we saw towards the end there, the withdrawal symptoms from opioids. Yeah.
And then the third part of your conclusion, that's just what you've already told us, that your conclusion that you believe the conduct was, that he knew the conduct was wrong.
Yes, sir.
You indicated this was a difficult case.
Especially arriving at a precise diagnosis, yes. It wasn't difficult, in my opinion, to arrive at the opinion that he knew his conduct was wrong. It was in trying to ferret out the effects of drugs and the effects of a severe mental disease and defect.
You have a mixture of different kinds of drugs also,
Correct.
and there's a combination effect that is difficult to determine, correct?
That's possible, yes.
And you're relying upon his self-reporting of that, correct? To a certain extent.
Yes, yes.
You didn't have the drug test or anything to know what he had in his system back in September, of course, not 2016.
No, I did not.
The documents that I'm showing you defendants exhibit 2, are those the type of documents that you rely upon in doing these type of evaluations?
Yes.
Here at this time, they're offering defendants exhibit 2.
Defendant's Exhibit 2 is admitted.
That's what
Ms. Chelsea?
Just you, Your Honor. Dr. Price, you were in the courtroom when Dr. Falls testified yesterday, were you not?
Yes.
He had mentioned, would you agree with me that his opinion that the defendant didn't appreciate the wrongfulness of his actions was based, for the most part, on self-reporting on the part of the defendant, Kody Lott?
I remember him using also the behavioral signs, but he also included a lot about the self-report, especially concerning disordered thinking and this psychotic thinking.
And then so he mentioned that it cancels them out. Do you know what that phrase meant?
I think so. The way I interpreted that was that Dr. Falls did a very thorough job of outlining the factors that indicate that he knew it was wrong, and then he listed factors that would support that he didn't know it was wrong that pertain to the delusional thinking. And so he in essence said, in spite of all of the behaviors, the signs that indicate he knew it was wrong, he couldn't have known it was wrong because he was delusional.
Based upon your 35 years of experience, do you agree with that proposition?
I do not, and that's probably the major disagreement that I have with Dr. Falls.
You do know this is the first time he ever testified regarding sanity, correct?
That's what I understand.
And you were stating earlier that he basically said that he knew he was going to prison, and so he wanted it to be worth it.
Right.
And so that's part of the motivation for killing Landavazo.
That's what he said, yes.
And so could he have done that so it pretty much forces his hand to go to prison so he doesn't have to make the choice to stop drugs?
And other choices to make about living independently too.
And then is it common for some prisoners who are in prison and it's structured and they function relatively well,
Yes.
and they go out to the general population and they can't function because they don't have that structure, and so they commit a new offense so they go back to where they can handle life?
Yes, it's for many, it's easier in prison in solitary confinement because they don't have to deal with other inmates. Some like that better because they're afraid. Some in solitary confinement decompensate though. So it just depends on the individual.
And then the defendant, although he was discharged a year prior to the committing the murder and the aggravated assault, he was prescribed medication, was he not?
He was.
And did he, to your knowledge, comply and take that medication?
To my knowledge, he did not. He told me that he was not compliant with the psychiatric medication.
Instead, he made a choice to continue his voluntary use of illicit drugs
Correct.
up into and through the time of his arrest.
Yes.
Did he also, when he was researching things, did he tell you that he researched certain killers?
Yes.
Do you remember some of those killers?
Well, he mentioned Charles Manson, and he mentioned also a case that I had heard about. The guy's name was Ricky Casso, who murdered a friend of his in some type of satanic ritual while using drugs.
And then, did he tell you that he missed the drugs?
He did.
Did he tell you that if he were released from jail or prison that he would do drugs again?
He did.
And then, finally, you mentioned that the behavior indicators are more important than the self-reporting indicators.
That's correct.
And in your 35 years of experience, you have never had a case where you had so many behavioral indicators that show that a defendant understood the wrongfulness of his acts.
That's correct.
Pass the witness.
Doctor, you indicated that Kody Lott felt that this action, this conduct would magically solve his problems.
Yes.
That's what.
Dr. Falls did not conduct any tests, did he?
No.
And then you conducted tests, and why did you conduct those tests?
Well, to help obtain information about his current mental state, to see if it was consistent with what I could find out about his state of mind at the time of the offense, and also to evaluate the response style to see if there was a tendency to either engage in positive impression management or negative impression management, which is exaggeration of problems, which is what I found.
And so when you interviewed the defendant, the trial had been set, had it not?
Yes.
And it was coming up pretty fast, was it not?
About a month.
And you knew, because the defense had already filed a motion to plead not guilty by reason of insanity.
Yes, that's the reason that I was retained.
And so is that important for you when you saw that the defendant was malingering or exaggerating his symptoms?
Yes.
And why is that?
Well, I had to be more focused on facts, information in the records, information about what he did, than necessarily what he told me, because he was likely telling me things that were exaggerations of the problems that I believed that he had. But it made it more difficult for me to do the diagnostic work here.
So he's basically hoping that he could fool you.
Well, I would say at least influencing what I might have to say,
But it did not.
not in the direction that I believe he probably would have liked for it to go.
That's what it is.
Doctor, the bottom line, there was a severe mental disease or defect, correct?
Correct.
We're talking about just about the wrongfulness here, is that right?
I think that's the
Bottom line.
that's where the rubber meets the road here.
Then it's Exhibit 2, which is the records of the behavior of a year before, are not under the influence of any, as far as we know, any offense or any crime that had been committed right about the shooting of girls, correct?
There had been, well,
This
not,
case didn't occur at the time that he was in the hospital that generated Defendant's Exhibit 2.
right, as to whether or not there were any other legal context, I'd have to
Right.
look at the
There's no
records again.
information of that at this point.
Right, not that I can recall.
Okay, thank you. That's good.
Doctor, you relied upon those records in determining that the defendant was sane at the time of the offense. Did you not take that into account?
I did.
And prison, there's a high population in prison with defendants that have, they're serving sentences that have mental illnesses, correct?
I'm going to object that speculation.
You've dealt with inmates in prison that have had mental illnesses, have you not?
Yes.
Absolutely.
No further.
Thank you, Doctor. You may step down.
You're on the state of rest. On the floor.
Your copies to use, and I read from the original, and those are your copies to use during your deliberation. When you're prepared to return your verdict, be sure you did on this original. The main difference is that mine's got the clerk's file stamp on the front, so be sure you presiding juror has this one. Once the charge is presented, we'll hear initial arguments from the state and the defense. We'll take about a 15-minute break, and then we'll conclude the argument, and you'll be allowed to deliberate your verdict. Ladies and gentlemen of the jury, the defendant, Kody Lott, stands charged by indictment with the felony offenses of murder and aggravated assault, alleged to have been committed in Wichita County, Texas, on or about September 2nd, 2016. To this charge, the defendant is pled not guilty. You are instructed that the law applicable to this case is as follows. 1. A person commits murder if he intentionally or knowingly causes the death of an individual. Individual means a human being who has been born and is alive. Bodily injury means physical pain, illness, or any impairment of physical condition. Act means a bodily movement, whether voluntary or involuntary, and includes speech. Murder and aggravated assault are felony offenses. A person commits the offense of aggravated assault if he intentionally, knowingly, or recklessly causes bodily injury to another and uses or exhibits a deadly weapon during the commission of the assault. Deadly weapon means a firearm. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. 2. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 3. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. 4. In a criminal case, the law permits the defendant to testify in his own behalf, but the same law provides that his failure to testify shall not be considered as a circumstance against him. You will, therefore, not consider the failure of a defendant to testify as a circumstance against him, and you will not, In your retirement to consider your verdict, allude to, comment on, or in any manner refer to the fact that the defendant has not testified. 5, you may not consider in your deliberation the potential consequences to the defendant of a verdict of not guilty by reason of insanity. 6, voluntary intoxication does not constitute a defense to the commission of a crime. Intoxication means a disturbance of mental or physical capacity resulting from the introduction of any substance into the body. 7, you are instructed that unless you believe from the evidence beyond a reasonable doubt that the alleged confession or statement given to Officer Killingsworth introduced into evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have a reasonable doubt thereof, you shall not consider such alleged statement or confession for any purpose nor any evidence obtained as a result thereof. 8, you are further instructed, as part of the law in this case, the indictment against the defendant is not evidence of the case. The true and sole use of the indictment is to charge the offense and to inform the defendant of the offense alleged. The reading of the indictment to the jury and the statement of the case of the state against the defendant cannot be considered as a fact or circumstance against the defendant in your deliberations. In deliberating on the cause, you are not to refer to or discuss any matter or issue not in evidence before you. In determining the guilt or innocence of the defendant, you shall not discuss or consider punishment, if any, which may be assessed against the defendant in the event the defendant is found guilty beyond a reasonable doubt. You are charged that it is only from the witness stand that the jury is permitted to receive evidence regarding the case or any witness therein. No juror is permitted to communicate to any other juror anything he or she may have heard regarding the case or any witness therein from any source other than the witness stand. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you're bound to receive the law from the court, which is herein given you, and be governed thereby. Do not let bias, prejudice, sympathy, resentment, or any such emotion play any part in your deliberations. 9, defendants are presumed to be sane, and the state carries no burden to prove sanity. It is an affirmative defense to prosecution that at the time of the conduct charged, the defendant, as a result of severe mental disease or defect, did not know that his conduct was wrong. The term mental disease or defect does not include an abnormality manifested only by repeated criminal or otherwise antisocial behavior conduct. The severe mental disease or defect must have existed at the very time or times inquired about, that is, at the very time of the alleged commission of the offense. The burden of proof is on the defendant to prove the affirmative defense of insanity by a preponderance of the evidence. The term preponderance of the evidence means the greater weight and degree of the credible evidence in the case. 10, count 1. Now, bearing in mind the foregoing instructions, if you believe from the evidence beyond a reasonable doubt that the defendant, Kody Lott, on or about September 2nd, 2016, in the county of Wichita and state of Texas, intentionally and knowingly caused the death of Lauren Landavazo, an individual, by shooting Lauren Landavazo about the body and or head, then you will find the defendant guilty of the offense of murder, and so say by your verdict. But if you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant. 11, count 2. Now, bearing in mind the foregoing instructions, if you believe from the evidence beyond a reasonable doubt that the defendant, Kody Lott, on or about September 2nd, 2016, in the county of Wichita and state of Texas, intentionally, knowingly, or recklessly caused bodily injury to Makayla Smith by shooting the body of said Makayla Smith with a firearm, and the defendant did then and there use or exhibit a deadly weapon to wit a firearm during the commission of said assault, then you will find the defendant guilty of the offense of aggravated assault, so say by your verdict. But if you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant. 12, count 1. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Kody Lott, committed the offense of murder as a lesbian indictment, but you further find by preponderance of the evidence at the time of the conduct charged, the defendant, as a result of severe mental disease or defect, did not know that his conduct was wrong, you will acquit the defendant, say by your verdict, not guilty by reason of insanity. However, if you find from the evidence beyond a reasonable doubt that the defendant, Kody Lott, committed the offense of murder as a lesbian indictment, and you further find the defendant has not proved by preponderance of the evidence that the defendant, as a result of severe mental disease or defect, did not know his conduct was wrong, you will find the defendant guilty of the offense of murder, and so say by your verdict. 13, count 2. Now, bearing in mind the foregoing instruction, if you find from the evidence beyond a reasonable doubt that the defendant, Kody Lott, committed the offense of aggravated assault as a lesbian indictment, but you further find by preponderance of the evidence that at the time of the conduct charged, the defendant, as a result of severe mental disease or defect, did not know that his conduct was wrong, you will acquit the defendant and say by your verdict, not guilty by reason of insanity. However, if you find from the evidence beyond a reasonable doubt that the defendant, Kody Lott, committed the offense of aggravated assault as a lesbian indictment, and you further find that the defendant has not proved by preponderance of the evidence that the defendant, as a result of severe mental disease or defect, did not know that his conduct was wrong, you will find the defendant guilty of the offense of aggravated assault, and so say by your verdict. 14. In addition, if you find the defendant guilty of a felony offense, you must further find beyond a reasonable doubt whether the defendant used or exhibited a deadly weapon, namely a firearm, during the commission of the offense. Now, bearing in mind the foregoing instructions, if you believe beyond a reasonable doubt that a deadly weapon, namely a firearm, was used or exhibited during the commission of murder as charged in the indictment, then you must make an affirmative finding as to that special issue. But if you have a reasonable doubt that a deadly weapon, namely a firearm, was used or exhibited during the commission of a felony offense, then you must make a negative finding as to that special issue. 15. After the reading of this charge, you shall not be permitted to separate from each other, nor shall you talk with anyone not of your jury. After argument of counsel, excuse me, you will retire and select one of your members as a presiding juror. It is the presiding juror's duty to preside at your deliberations and to vote with you on arriving at a unanimous verdict. After you have arrived at your verdict, you may use one of the forms for each count attached hereto by having the presiding juror sign his or her name to the particular form that conforms to your verdict. But in no event shall he or she sign more than one of such forms for each count, with the exception of signing the verdict form regarding your deadly weapon finding for each count. After you have retired to consider your verdict, no one has the authority to communicate with you except the officer who has you in charge. You may communicate with this court in writing, signed by your presiding juror, through the officer who has you in charge. Do not attempt to talk to the officer, the attorneys, or the court concerning the questions you may have. Signed, Robert P. Brotherton, presiding judge. The following verdict forms are attached for your use. First, verdict of the jury, count 1. We, the jury, find the defendant, Kody Lott, guilty of the offense of murder as alleged in the indictment. Or, verdict of the jury, count 1. We, the jury, find the defendant, Kody Lott, not guilty of the offense of murder as alleged in the indictment. Or, verdict of the jury, count 1. We, the jury, find the defendant, Kody Lott, is not guilty by reason of insanity of the offense of murder. In the weapon verdict, count 1. Having found the defendant guilty of murder as charged in the indictment, we, the jury, further find, either find or do not find, that a deadly weapon, namely a firearm, was used or exhibited during the commission of the felony offense. Next, verdict of the jury, count 2. We, the jury, find the defendant, Kody Lott, guilty of the offense of aggravated assault as alleged in the indictment. Or, verdict of the jury, count 2. We, the jury, find the defendant, Kody Lott, not guilty of the offense of aggravated assault as alleged in the indictment. Or, verdict of the jury, count 2. We, the jury, find the defendant, Kody Lott, not guilty by reason of insanity of the offense of aggravated assault. And then the final verdict form, deadly weapon verdict, count 2. Having found the defendant guilty of aggravated assault as charged in the indictment, we, the jury, further find or do not find that a deadly weapon, namely a firearm, was used or exhibited during the commission of the felony offense. Your presiding juror is instructed to sign the applicable jury form that conforms to your verdict as to each count and as to each special finding. With that, the state may proceed.